Hi, my name is Beth Goodell. I'm a lawyer with Community Legal Services in Philadelphia. I've been working in the area of foreclosure defense and bankruptcy for about 13 years. The other members of the panel, although I may end up doing most of the talking for this period of time before lunch, but also on the panel are Peter Schneider, who is also a senior lawyer at Community Legal Services in Philadelphia, and Michael McKeever, who is a partner in the firm Goldbeck, McCafferty, and McKeever, a plaintiff side foreclosure firm that works throughout the state of Pennsylvania. And I ask you, Peter and Mike, as I'm talking through the issues in the first section, that feel free to chime in with comments. And also feel free to ask questions whenever you have them. You don't have to wait until the end. I have to apologize to the housing counselors in the room because this session is primarily geared towards lawyers. I wanted to go into some level of detail on the implications in foreclosure defense practice of these issues that we're kind of labeling robo-signer issues. And I get into some level of detail that a young paralegal in my office commented to me when I explained it to her. She's a recent college graduate, so I tried to capture her expression as well as the words. Wow, this is really interesting in a really tedious sort of way. And it is, and I'm always hopeful that the lawyers can hang in there for the tedious side of it. And I apologize to the housing counselors for that side of it. But David and John referred to this robo-signing issue, and that's sort of a catchphrase, as David mentioned, for this phenomenon in the mortgage servicing world of relatively low-level employees signing lots and lots and lots of documents without reading them, without knowing the content, and those documents being necessary for the foreclosure process in whatever state, whatever jurisdiction they're in. This has been going on for years. It's not a new process, but what broke it into the attention of the general public and the regulators and investigators was attention that was paid in the media. And what brought it to the attention of the media fairly recently, that there were legal services and private lawyers who'd been slogging away in this field for a long time, who got on record through depositions in individual cases statements by the so-called robo-signers that, yes, I signed this document, I signed hundreds of documents like this a day, and no, I didn't read it, and no, I didn't know what the document says. Having got that testimony on the record, it was now easy for reporters to understand the issue and report on it, and it was frankly all that media attention that pushed the issue into the area of investigation and enforcement. But those of us legal services lawyers who've been working on this in these types of cases have been raising these issues for quite a while. I think we're at the point now where it's getting so much public attention, more judges are seeing these issues, are looking at them in depth, and are writing opinions that then can be useful in other foreclosure cases. And we're going to look at a very recent opinion that's very helpful for, I think, foreclosure defense in Pennsylvania, even though it came out of a bankruptcy court in New Jersey. The materials for this session, I numbered them with a separate numbering system it's a little bit different than the numbers for the general booklet. And you can see the numbers in the lower right-hand corner of the pages. My numbers are preceded by a P, P1, P2. When I refer to numbers, that's the number that I'll be referring to. You hear the catchphrase, and by the way, there is a couple examples of robo-signed documents, and I'm going to have us turn to one of them just to start with, although we'll look at some of the other materials as well. But on page P80, which is page 70 of the general book, there's an affidavit in support of a summary judgment motion in a foreclosure case that is a robo-signed document by a gentleman who's sort of now the poster child, unfortunately, in his life for this robo-signing phenomenon. His name is Jeffrey Steffen. He's an employee of GMAC Mortgage, which is headquartered just outside of Philadelphia. He signed this document as a limited signing officer for GMAC, and on the top of page P81, paragraph 2 in the affidavit, he says, "I have reviewed the business records that relate to the mortgage loan account that forms the basis of this action, this foreclosure action," yada, yada, yada. That's a lie to the court. He hadn't reviewed the business records. And he goes on to sign this under oath. That's perjury. And that's the sense in which robo-signing in part constitutes potentially a criminal action. Perjury, there are criminal statutes regarding perjury. It's one angle on this situation that the investigators and the law enforcement authorities could pursue. He and other employees of GMAC and other employees for servicers did this in thousands and thousands of situations. Does that mean any of these statements in this affidavit aren't accurate regarding the amount of the debt, the missed payments, and other key factual issues in the foreclosure? Maybe or maybe not. The perjury kind of stands alone as a violation of law apart from the content of the document, the factual content of the document. The phrase wrongful foreclosure or fraudulent foreclosure gets used a lot in the media and in discussions of these issues. And I tend to think about three different situations where there might be a wrongful foreclosure based on defective or perjurious documents that have been signed by people who work for the mortgage companies. One situation is, I think, the one that the regulators and the advocates for homeowners all hope rise to the top of the pile. That is somebody who wasn't behind on a mortgage when the foreclosure process started. That the mortgage company wrongfully stopped accepting payments or force-placed insurance when they shouldn't have, or paid the taxes when they shouldn't have, and then increased the payment that the homeowner couldn't make, and then started foreclosure. That kind of situation, we've even heard of situations, and I had one of these cases, where the homeowner really didn't owe any money. They'd paid off the mortgage, and the record keeping of the servicer was such that the letters kept coming and the collection efforts kept going and the foreclosure got filed. If you're working with homeowners and you come across that type of situation, that kind of case has got to get to a lawyer, right? If the mortgage company hasn't stopped the foreclosure, or if they've kind of corrected things, but the stigma of the foreclosure is still there in the credit report or in the public records, a lawyer can do a lot with that kind of case. And everybody would agree that's a wrongful foreclosure. But a situation now that is fairly recent is if the mortgage company isn't performing the loan modification process required by HAMP or other modification programs properly. So you have a lot of situations where the homeowner has a loan, not making the payments, but foreclosure could be wrongful if they're not there, if the servicer isn't complying with the loan modification process. Now you housing counselors and legal services lawyers see a lot of those. They should be rising to the level, I think, the sort of level of outrage of the first kind of case where there's really no debt in arrears. But I think the numbers are just so massive that it's hard to get those kind of cases to rise up to the top and get a lawyer to attend to any one individual case. But there are some lawyers who are bringing lawsuits on behalf of homeowners who have had very bad servicing related to the loan modification program. And the failure to properly offer and consider a loan modification can be a defense to the foreclosure. So those are two situations where we might use the phrase wrongful foreclosure. The third that I have in mind is the issue that I'm going to spend most of the time in this session on. And it's technical and legal, but also I think has pretty profound implications if you're a lawyer who's defending foreclosures for homeowners. And it's not an area that I would recommend that housing counselors try to get into discussions with the servicers over. It's really a legal-oriented problem, and that's proper ownership of the loan at issue. And it's my impression that given the securitization of mortgage loans, that most mortgage loans at this point in time have a variation on this problem, that the proper ownership of the loan that's being foreclosed could be called into question. And that's the issue that I refer to as, who has the note and why does it matter? I don't know how many of you have heard a description of the securitization process, the process by which lots and lots of individual mortgage loans got packaged into securities with shares or certificates being sold to investors. But that's the way that most mortgages are owned these days, that the parties that have the right to receive the stream of payments due under the loans isn't an individual bank or mortgage company. It's a set of investors who have bought shares in that particular loan trust. The process that was set up to turn individual loans into the collateral for these trusts was fairly complicated, and it involved right from the beginning a set of transfers among different parties that are identified in these securitization documents. I actually can't see that screen. Usually when I do PowerPoints, I can see the screen, so I know if I'm on the right one. I will. I still can't see that. I meant the big screen. No, you can't turn the big screen. But I think it's probably hard enough for you all to see the big screen, let alone if we turn it. But I'll try to follow along with my PowerPoint and the copy that I have. So the securitization process was set up with several transfers of the loan right at the beginning in order to protect the ultimate intended owner of the loan, the trust, from any claims that could have been raised against the originator of the loan or from a bankruptcy filing by the originator of the loan. So this process was set up where at least 3 different transfers of the loan were supposed to happen right away. The parties to a securitization are identified in documents that are called pooling and servicing agreement or loan sale agreement or the trust creation agreement. I've included samples of some such documents starting at page 37, my page 37 of the materials. You have the originator of the loan. That would be the loan company like AmeriQuest or WMC Mortgage. That's the company that the homeowner signs the agreements with, identified in those original loan documents. Then you have another party that's typically called the seller, another party that's called the depositor, and another party that's called the trust with the trustee. The securitization documents state that the loan is supposed to be transferred from the originator to the seller to the depositor and then into the trust by a transfer to the trustee. The sample trust documents in the materials shows you that. It shows you at the top of my page 37, you can see the name of the trust. The names of the trust tends to be these really long names that identify typically the depositor. It's the name of the trust often includes the name of that last company that was to transfer the loan into the trust. And so in this sample, it's the Amortizing Residential Collateral Trust Mortgage Pass-Through Certificates Series, I can't even read that, 2000-BC3. And for those of you who are lawyers who defend foreclosures, that's your plaintiff. That's the party that's identified on the complaint as the foreclosing party. You actually this is minus the name of the trustee. So there, as the plaintiff in a foreclosure, there should be the name of the trustee as trustee for something like that name. If you turn to page 42 and on to page 43, in this particular agreement, it identifies the originators, the seller, the depositor, and the trustee in those portions that I underlined. And then on the next page, it identifies a closing date for this whole series of transactions. In this case, it was September 8th of 2000. The closing date typically is the same year that's identified in the name of the trust. This was a 2000 trust. It has a closing date before the end of 2000. That's the date by which all the loans were supposed to be transferred into the trust. That series of 3 or 4 transfers was all supposed to happen by that date. So when I get a foreclosure complaint that identifies blah, 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 trust 2000-3, and I see an assignment of mortgage that's dated later than 2000, typically pretty close to the date that the foreclosure was filed, I know just on the basis of that assignment that there's a problem. The assignment of mortgage is supposed to be the document that transfers the mortgage to a new owner. But this securitization contract says that transfer was supposed to have happened by September 9th of 2000. I see an assignment that says 2003, and I know that that assignment can't be meaningful. It's not proof that the plaintiff owns this loan because this assignment was executed well after the date when this loan was supposed to have been put into this trust. So that to me is the initial hook that I've got to raise a defense in that foreclosure case that this plaintiff doesn't properly own this loan and can't foreclose on it. It also says to me that the assignment of mortgage isn't going to be proof that the loan is owned by this trust, and that I'm going to ask for and insist on seeing the original note. Because any mortgage loan transaction has those 2 key contracts: the note, which creates the debt, the borrowing and the obligation to pay it back, and the mortgage, which is the security instrument that goes along with that debt. You don't pay that debt, the mortgage lets me take a particular property as a result of your not paying the debt. I want to spend just a moment talking in a bit more detail about the documents, the securitization documents, because even though you may know on the basis of just the date identified in the complaint as in the name of the trust, the date that the trust was created, and the date of the assignment, that there's an issue, it's not quite enough to convince a judge that this foreclosure should not be allowed to go forward. You can ask for, and in the portion of the program after lunch, Peter Schneider is going to talk in more detail about how to get these documents through discovery, or at least how to ask for them, if not how to get them. But I find it much more convenient if I can just find them myself, so I don't have to worry about discovery. Many of the trusts, in many of these transactions, the investment opportunities are public. These were transactions that had to be registered with the Securities and Exchange Commission, and you can find the relevant documents by going to the SEC's website. The documents that you can obtain from the SEC's website, the one that seems to be the easiest to find is the prospectus supplement. Now, the prospectus isn't the contract among the different parties to the transaction, but the prospectus is the document that the companies release to the public to explain this investment opportunity. So if you want to know whether or not you're going to buy into this particular investment, you can look at the prospectus.
And don't buy it. It's not doing well.
It's not doing well, don't buy it. My spouse came home once with an investment. She had an investment advisor who'd bought into a securitization, a mortgage trust. And I looked at just the name of it and said, oh, you got to get rid of that. So fortunately, that was several years ago, and she did. But anyway, the prospectus supplement is called Form 424B5. And it contains all the same information that the pooling and servicing agreement does. The document that we were just looking at is actually an excerpt from a prospectus supplement, not the pooling and servicing agreement itself, but it contains the same information. So the prospectus is just this representation sort of to the world about this investment opportunity. The pooling and servicing agreement is the actual agreement among the parties, the depositor, the trust, and other parties that are creating this investment opportunity. Then sometimes, and often the pooling and servicing agreement serves as the trust agreement itself. It sets up the trust as well as the terms for pulling the mortgages together and servicing the loans. But there's sometimes a separate trust agreement, and there's sometimes a separate loan purchase agreement. Often those documents are attached to the pooling and servicing agreement or to the prospectus supplement. So if you can find the prospectus supplement on the SEC's website, you can then pull up these other documents as well. This is the part where my paralegal said, oh, this is interesting but tedious. So we were sitting there going online to pull up a sample, to pull up the documents in a particular foreclosure case that we were working on. You can just Google the name of the trust. I've often been able to come up with the link to the SEC records by Googling the name of the trust. The trick there is that you got to have the full name of the trust. And sometimes you've got that. Hopefully all the time you get that. If there's a foreclosure complaint, it's identified the plaintiff properly with the full name of the trust.
Although, let me say, there's one issue that comes up is Fannie and perhaps Freddie seem to have instructions out there that actions are supposed to be filed in the name of the servicer. And if that's the case, the servicer is going to be the plaintiff in the complaint, and you're not going to be able to easily find the name of the trust. There's questions as to the legality in Pennsylvania of filing a complaint in that manner, because Pennsylvania criminal law says that it's a misdemeanor for a collection agent, which servicers probably are, to file an action in their own name and not in the name of the principal. But that said, it is often done and makes this task a lot more difficult.
And at that point, and as Peter will address later, you may be, your best way of getting the information is to go with discovery in the foreclosure case. Another way to get the name of the trust, I suppose if you have a case that's not yet in foreclosure, or that the foreclosure complaint itself doesn't identify the trust, you can go to the assignment of mortgage, because often the assignment of mortgage, even though it's dated even though it's not an effective assignment of mortgage, in my opinion, it at least identifies the party, the trust, which is supposed to own the loan. If you look in your materials at P78, there's a sample assignment of mortgage. In our practice, we have the advantage of an online system for retrieving documents that have been recorded in the deed records. So we can go online and very easily see from the original mortgage through to any assignments of mortgage that have been recorded, not only that they exist, but we can pull them up as well. And that's hugely helpful for us. And if you don't have that capacity, it's much harder to do this. But so, you go in, I pull up this on the online access to public records, and I see that the assignee of the mortgage is supposed to be U.S. Bank as trustee of 2007-TC1. And I know, just because I've seen a lot of these trust names, that trust name is missing some words. It's got the last part of the name that usually has the year and some other letters, but it doesn't have the name of the depositor. There's supposed to be a company mentioned there in that trust name. So this means that I'm going to have trouble finding this in the SEC website, but it also means that there's another reason why this particular assignment of mortgage is ineffective, because it hasn't named the full party to whom the loan was supposed to be assigned. If you flip back one page to P77, you see an assignment of mortgage that does give the full name of a trust. In that first paragraph, Deutsche Bank National Trust Company as trustee for HASCO 2007-WF1. That looks like a full trust name. That name of HASCO was the depositor, and I need that because in the SEC filings, it's the name of the depositor that these filings are made under. So in a case where I feel like I do have the full name of the trust, I can go to the SEC website, and I've included in the PowerPoint the website and the process that you use to get to the right part, the search screen. And you enter the name of the trust, the depositor. You don't enter the name of the trustee. It's not U.S. Bank National Association. It's HASCO-2007-TC1. You plug that in, and if that was a publicly traded investment, you will find the documents on the SEC website. Sometimes it doesn't work. You either get nothing or you get a long list of trusts with very similar names, but you can't quite find the one that is identified either in the complaint or on the assignment. I tend to print those screens out, and if I'm responding to a summary judgment motion, I attach it and say, Your Honor, I tried to find these trust documents, and I don't see a trust with that name. And I asked the other side in discovery for those documents, and they didn't produce them. So it's inappropriate to grant summary judgment because I've got this facial issue of the date on the assignment being improper compared to the name of the trust, and they haven't given me the rest of the documents I've asked for, so you must deny summary judgment because standing is at issue in this case. The cases where these issues are coming up go to another level of these issues. Well, what if the assignment seems on its face not to be correct? Where's the note, right? The assignments aren't the end of the story. I wish it was. I think we'd prevail in a lot of foreclosure cases, frankly, if we could just point out the error in the assignment and say, end of story, this foreclosure should be dismissed. But the real story is, where's the debt instrument? Where's the note? Even if the assignment of mortgage wasn't done properly, was the note itself transferred properly so that the plaintiff in the foreclosure can say, okay, we screwed up the assignment, but here's the note, and we possess it, and therefore we're the proper plaintiff in the foreclosure. That issue brings up a lot of different sources for how notes are supposed to be transferred. And one reasonable place to start is with the securitization documents themselves. What do they say about how a party becomes the owner of this loan after it's been originated by the lender? On page 47, P47, along with the excerpt from a prospectus supplement, there's an excerpt from a trust agreement. And the portions that I've underlined, concurrently with the execution and delivery of this agreement, the trust agreement, the depositor, that's that party, the last stop before the trust, does hereby transfer all the right, title, and interest in and to the mortgage loans. And the depositor has delivered to and deposited with the custodian the following documents: the original mortgage note endorsed without recourse in proper form or in blank, with all necessary intervening endorsements as applicable. So it says something about what's supposed to happen, what was supposed to happen, and all this is tied to that closing date that's identified in the trust in the pooling and servicing agreement and also in this trust agreement. So by that closing date, the note itself was supposed to have been endorsed in proper form with all necessary intervening endorsements into the possession of the trustee. So what does proper form mean, and what's an endorsement? Where do you look for more detail on whether or not the note has been transferred properly? For those of us who are lawyers, maybe like me, you didn't pay all that much attention in contracts to the UCC section. But that's the main source of law regarding what's the proper way to transfer a note. The Pennsylvania UCC, and I'm going to point your attention to a page in the documents, page 49, P49, where there's some detail about Pennsylvania's version of the Uniform Commercial Code. And this really is uniform. If you look at most states' versions of this, it says the same thing. Defines a holder, who's a holder of a note. It defines negotiation, which is the process of transferring, defines what endorsement is. And essentially, what should have happened with these 3 or so transfers right at the beginning is that each note should have been signed over to the next owner, kind of like a check. You know what to do with a check when you want to make it payable to somebody else. You turn it over and you write pay to you sign it, pay to somebody else. And if you sign it and then lose it, whoever picks it up can cash it, in theory. So you got to be really careful about signing checks, endorsing checks, and signing them over to people. So in theory, that's what's supposed to happen with these mortgage-backed notes, that for each transfer, there should be a signature by the party that currently owns the note or holds the note over to the next party. And it can be in blank, in which case the holder, the party in possession of the note, may have the authority to enforce it. I have lost track of where we are on the PowerPoint. I'm gonna, that doesn't look like the screen that goes with this portion.
There's some sort of background that steps on there.
There's a house in the background of the PowerPoint.
Beth, one question.
Yes, thank
You know, I certainly don't want to minimize the document issues or the robo-signing issues, but a couple of the commentators on the Kemp case, which I would assume you're talking about or moving towards, which is the New Jersey decision, 2 issues that came up. One is, could not the servicer of the loan be considered an agent of the trust, and therefore, under the UCC, hold the note? Again, this is from some commentators, 20/20 hindsight, looking at the case, arguing that. And then the American Securitization Forum has a white paper out that indicates that each of the trust agreements has pretty much of a standard savings clause, if you will, that says, if we didn't document this right, then we always reserve the right to go back and document it. What do you consider to be the validity of those counter arguments?
So the problem, I think, with the clause that would allow them to go back and fix things is that it runs into trust law and to the IRS provisions. And there are a lot of issues circling around on these topics. One of them is that New York trust law was the law of choice for most of these securitization documents, that they were all set up as trusts under New York law. So you need to look to New York law regarding trusts as to when property has been transferred into the trust properly. The other piece is IRS rules, because these trusts were set up as REMICs, real estate mortgage investment conduits, which have tax rules related to the tax status that the people who set up the investments and the investors who bought into it desired to have. They desired this particular tax status. And whether or not the provisions in the trust documents, if you're trying to say that although loans were not properly transferred at the time they should have been, we can look to this clause in the securitization agreements to get around that, whether or not you've now run afoul of New York State trust law or the IRS rules. And the servicers and the investors for whom they are servicing the loans may not want that to be the case. Even though they could make this argument, they perhaps don't want to because of the implications for the tax status or the status of the trust under New York law. There is a memo of law on New York trust law in the materials. There is also a document, it's testimony by a law professor who's written several law review articles as well as this testimony on the securitization process. That's Professor Adam Levinton. If you're taking a train back today and you're really into this subject matter and you want some reading, I would read Professor Levinton's article and then the New York Trust, maybe read the New York Trust memo first, because if you're close to falling asleep, that one will, you need to get through that one first. And I do, we're at the time for lunch now, but I do want to talk about the Kemp case. That's the case that Mike just mentioned is getting a lot of attention now, because unfortunately for the plaintiff in that, well, it was in a bankruptcy. Unfortunately for the mortgage company in that case, one of their employees came in and testified that the notes, all of these notes originated by Countrywide Home Mortgage, never left Countrywide. And that was an admission that is causing a lot of pain, because that means that basically that whole batch of loans originated by Countrywide wasn't transferred properly into the trust, because under the UCC, need endorsement, need possession. It needs to move into the hands of the trustee. So we're going to look at the Kemp case when we come back and then move into the next portion. Right. Thank you.
But don't leave quite yet. Brian, Brian Hudson's going to just say a few words before we break for lunch, and then this session is picking up right after lunch. So I just want to, as Brian's walking up, I just want to say, in fact, Brian is coming from negotiations with HUD over some of the issues that were talked about this morning. We appreciate how supportive Brian has been and PHFA has been in legal services, having a role and a partnership in trying to help get referrals from counseling agencies, provide legal services. So thanks for all of your support, Brian, and please take a few minutes.
Thank you. Thank you. Good afternoon, everyone. I won't stand too long between you and lunch. I know you've had a busy morning. I just want to thank Sam Milkus and his group, the plan, and all of our counseling partners. I see a lot of familiar faces in the audience for doing such a great job, because without your help and your effort, I would not be able to go to Washington and lobby for dollars for Pennsylvania. Also want to recognize my board member, Mark Swartz, who's trying to hide back there, since I'd like to put him on the spot. Mark, always thank you for your support going forward. As Sam mentioned, I am just back from D.C. We actually met with Secretary Donovan and some members of HUD to basically talk about a number of issues. But I know what's near and dear is the $105 million that the state is receiving for homeowner help. We basically have asked HUD for some flexibility with the program. Ideally, I would like for them to give all the money to us and let us run it like we run HEMAP. And will that happen? Most likely not, but I'm going to push for as much flexibility as we can get from them. I know there was a panel this morning, and I want to thank John Gore and Darryl Rotz for delivering the message and how it's structured right now. Not all of my counterparts are getting the homeowner help money, and there's about 6 to 8 states who are actually receiving the funds. And we're fortunate that we have a program here that has a long track record, and that's my argument that I've certainly been taking to Washington. The other things that we did speak to the Secretary about was affordable housing as a whole, and we want to make sure that we have a seat at the table. With GSE reform, a number of options are being looked at. What will Fannie and Freddie look like? Do they break them up into 12 separate entities, which is one of the concepts that is being vetted on the table. We just want to make sure that the clients that we serve, those most in need, still have access to mortgage capital. So that's a message that we want to deliver to the Secretary and the administration. We also wanted to make sure that, from an FHA standpoint, that the HFAs become the partner to fill that affordable housing commitment. We want a seat at the table because we think we do a great job. We have a great partnership network with the counseling agencies and the legal network to make sure that they're ready for homeowner. And the HFAs have been gathering our data to show that track record. So we want to make sure that affordable housing doesn't get put on the back burner, so those first-time home buyers still have access to mortgage capital. The good news is that, according to the latest mortgage banker statistics, that Pennsylvania still is ranking 34th, 32nd, 33rd, 34th in foreclosures. But the bad news is that we still have almost 170,000 subprime mortgages in Pennsylvania. And 10% of them are in foreclosure. And if you further drill down, the ARMs, there's about almost 45,000 ARMs, 32% delinquent, and 17% of them are in foreclosure. So we still have some issues here to deal with. I think we have a great network. With your help, we can help those homeowners who need it most. And I will tell you that of the $105 million that Pennsylvania were receiving, we definitely will have a carve out for counseling to pay the counselors to help us reach out to those homeowners. So I want to thank you for your work that you're doing. Yes, Mark. How did I know he was going to have a question? Well, all of the applicants, and again, I want to stress that some states are upset that they're not getting the money directly to the HFAs. The applications are due the 13th. Our indications that I was hoping it would be by year end, but since we're talking with a bureaucratic review, let's say, I think it won't be until January that we'll actually see the funds flowing. But I do want to touch on what we're going to be doing up until that time, since we will be receiving the funds. We're going to do an outreach, so we've already reached out to Department of Labor. I've had conversations with my counterpart, Secretary Sandy Vito, to actually send mailers to those homeowners who were receiving unemployment compensation to let them know that these funds will be available. So we're creating a wait list, if you will, so that once we do receive the funding, we'll be able to reach out to those homeowners. We're going to be doing advertising. You'll see commercials, and I won't necessarily be the one in those commercials this time around, but you'll see commercials telling homeowners where to go, and also listing the counseling agencies in that region where they can seek the help. We're going to be reaching out to financial institutions because we want to tap in. If you recall from the panel this morning, it's a little different from HEMAP. You don't have to have received an Act 91 notice, but you have to be behind, 3 months behind in your payments. So we want to get to the lending institutions before they go into foreclosure and tap into their database of homeowners who are slipping in their mortgages and then send mailers to those homeowners. How we expect to use the federal money first and then use HEMAP as a safety net, because all the applicants that come through your offices or through our doors may not be eligible for the HUD money because of some of the restrictions that are there. Meaning the 120% of median, which again, we're looking for some flexibility on that also. But we'll use HEMAP as a safety net to catch those homeowners so that we can use HEMAP to make sure that we're serving those most in need. So that's our game plan going forward. I'm expecting that I'll have a series of more conversations with HUD just to see how flexible they will be with the program. And what we're pushing is that we have a model that works. Can we keep it as much looking like HEMAP as we possibly can without having, let's say, an Act 91 notice? That's probably the best part, is that the homeowner doesn't have to be in foreclosure yet. So that's the piece that we would mind eliminating, if you will, with regard to federal money. But the income limits and a little discretion from the case of Pennsylvania, those are the issues that we're going to be pushing on. But I want to thank all of you for your support and your hard work in helping homeowners, and we're going to keep lobbying for funds for Pennsylvania. And at this point, I'll take are there any other questions regarding the federal funds or even PHFA's initiative with regards to HEMAP? Yes, Mark.
One of the issues that came up this morning was the possibility of using some federal funds
I didn't bring that up with them. I mean, obviously, that's something that we'll have a one-off. I'm in a room full of other states, so I couldn't necessarily dominate the conversation. But yeah, that's something that we certainly will be looking at with regards to that flexibility issue. How can we use it to? Ideally, I would like to create a revolving loan fund. So that would certainly give us the possibility to do that. Any other questions? Again, it's certainly been a pleasure to have you as a partner, and we're looking forward to working with you in the future. And I'll keep you posted as we move through the initiatives for saving homes. Thank you.
Thanks, Brian.